Welcome back to Court TV Live. I'm Matt Johnson in for Cody Thomas. Thanks for being with us on this busy day here at Court TV. Emotions ran incredibly high as testimony kicked off in Miami yesterday. Defendant George Pino, remember this, broke down in tears, sobbing as his defense attorney delivered opening statements, prompting the judge to recess court early on day one. But now we're in day two. And the defense finished their opening statement earlier this morning. And now the state has been calling witnesses, which has included the victim's father and the boat crash survivors. On the stand right now is one of those boat crash survivors by the name of Carolina Monterey. Let's get you back into the courtroom for more cross.
So now I want to talk a little bit about Labor Day weekend of 2022. You went there to celebrate little Ceci's birthday.
Yes.
Can you remind me what day you drove up?
Saturday, September 3rd.
Okay. Do you remember if at night, on Saturday night, you girls had lasagna for dinner?
I don't remember.
You don't remember if Miss Pino cooked lasagna that night?
I don't remember.
And your parents knew you were going to be staying at Ocean Reef Club with the Pinos, correct?
Yes.
Did your parents accompany you that weekend?
Can you rephrase the question?
Were your parents there with you that weekend at Ocean Reef Club?
No.
Did your parents know that you were going to take a boat ride with Mr. Pino at some point throughout the weekend?
I think so.
And your parents allowed you to go?
Yes.
Now let's talk about the sandbar. When you were at the sandbar at Billy's Point, would you say that most of the time you spent it was at or around Mr. Pino's boat?
Yes.
One moment, Your Honor. Miss Monterey, you were interviewed by an officer after the accident, right?
Yes.
Do you remember it was around April?
I don't remember the date.
Okay. And when you met with the officer after the accident, you told him that Pino was on the floor and he was bleeding, that he was unconscious.
I don't remember, but I guess I had to have said that.
And do you remember that you told the officer that he was lying on the floor, he was still next to you on the floor?
I don't remember.
If I show you something to refresh your recollection, do you think that might help?
Yes.
Your Honor, may I approach the witness?
Okay.
Your Honor, may I approach the witness?
Read it to yourself quietly. See if any of that refreshes your recollection.
All right, let's do this. Let's bring in my guests watching along with you at home. Still with us, we have criminal defense attorney and former lead prosecutor Bob Bianchi and criminal defense attorney and former prosecutor John Mobley. John, to you first. What do you think about the cross here? Is it moving the needle at all?
You know, I mean, the cross-examination for me is showing that, the defendant in this case, she's known his family for a long time. She's been friends with, I think, his daughter. She's been on his boat on more than one occasion. And in particular, what I thought was significant was that when, she was asked about whether or not her parents knew that she was going on the boat with him, her parents knew and didn't have a problem with it. So what that tells me is he didn't have any type of history of reckless or unsafe behavior, which I think makes a big difference in this case. Because, if the jury sees this as a defendant that has a history of being reckless and unsafe and, a dangerous, individual, that's going to be a problem. But if they see him as someone that was normally safe, that was, liked by the family, that they knew about his history, there was nothing to give them any kind of concerns, and they see this as just an isolated incident, then they're more inclined to find him not guilty.
Bob, and it seems to be along those lines that the defense has been leaning into is the risk factor and intention here, because the defense in their opening statement before they were interrupted by their client breaking down in tears, halting everything, was the fact that they kept on driving home the fact that his family was on board that boat too.
I hear this. I don't know where this cross is going, to be honest with you. I'm going to be frank with you. The way it's obviously a novice attorney. She needs to, through her questions, deliver to the jury what she's trying to get to. And if that's the point, fine. I wasn't getting that. And it doesn't make a difference. In fact, I can make an argument as a prosecutor that makes his conduct even more egregious, because parents put their trust in this guy because he posed to be this great person, this sober human being. And he went and he got drunk and he put a bunch of kids without life vests and put them on a boat and was speeding on the boat and went outside the lanes. And so that makes the conduct even worse. In the bottom line, it's just a question. This isn't whether he intended it. It's a manslaughter case. It's whether or not it was what he did that day. Not yesterday, not the day before, not last year. On that day, whether his actions were a conscious disregard to a known risk, drinking, speeding, and driving outside the lanes with a bunch of kids that are also drinking illegally is not a good look.
John, you were shaking your head. Was that in agreement, or did you want to say something in opposition?
I could not disagree more. And I think what I say all the time in criminal trials is, irrespective of the facts, you've got to take into account the intangibles. And the intangibles, are things that are beyond the facts, things about the case that might make a jury more or less comfortable in making a certain decision. And having a jury think your defendant's a nice person and not a bad guy, he's not reckless, that makes them less inclined to want to punish him. And that's something I don't think he probably took into account. Yeah, the fact of the facts and the law is the law, that's not going to be in dispute. However, that intangible, that choice the jury wants to make about whether or not they want to punish a person and brand someone as a criminal, that is something you have to always take into account. And I think smart defense attorneys use that to their advantage. I try to do it every time I can.
So, John, do you put him on the stand? Do you suggest to your client you should tell your side of the story? He's already having a big problem breaking down in court twice.
Well, what I always say, Matt, is that you ask 10 different lawyers, about whether or not that defendant should testify. You get 10 different answers or 100 different answers if you have 100 lawyers. My rule of thumb is always, I do not put a defendant up unless I believe the case, his testimony adds something the case needs from a legal standpoint. Okay, if the defendant cannot offer something we can't prove through other witnesses, I don't like putting the defendant up, because ultimately, you never know how he's going to testify, how they're going to respond to the cross, and that other intangible is, whether a jury decides they like somebody, and that's something that can affect an outcome. So my rule is, unless they need him, let him sit there and cry. Let the witnesses talk about how many times we went on his boat and went to his house, and he cooked on the grill for them and gave them rides home and always made sure they got home safe. Hey, I would put all those witnesses up and let him sit in that chair and cry.
Bob Bianchi, do you agree? Does he testify?
I try to, let's see if I can remember. I couldn't disagree more, okay? So with all due respect, we just got done saying about how his wife makes lasagna, and that he was not a big drinker and there was no history of this, somehow humanizes him to the jury. And don't get me wrong, humanizing him, we talked about this earlier, is very, very important. I just don't think this does it. But if you do want to do it, then you put him, look at the face right there. You put him on the stand, you let him break down, you let him say, oh my God, this was an accident. You let the defense get up there and say, millions of people go out on the boat and enjoy themselves on a nice day and have a couple of drinks. This was not because of his actions, but an unfortuitous accident. This poor, good man right here, not that his wife makes a good lasagna, the guy on the witness stand, that's the person you should give a break to. So if you want emotions to come out, you don't talk about on cross-examination making lasagna. You let the defendant get up there and testify so that they can see it from him. But I don't disagree. I don't want to put the guy on the stand. I don't think any of it makes a difference, because the judge specifically instructs them at the end that they're not to use sympathy, prejudice, or feelings of you liking somebody or not affect their decision about what happened on that day with those facts and the law. That's it.
John Mobley, I got about 30 seconds before I have to go to break.
If any attorney thinks that a jury doesn't consider sympathy in a decision they make, then they are dreaming. The judge is going to tell them who's going to tell them. The law is the law, but they're still human. They're still people. And I completely disagree. They are seeing all the points they're making. They are telling the story about this man in the community that's liked, that all the kids like, that all the parents like. And I don't think if they can paint that picture, the jury's not going to brand that man a criminal. They're going to think it's all.
We need to see you both in a trial together here at Court TV. Thank you, gentlemen. We do have to take a short break. Coming up, more testimony out of the state of Florida in the boat crash manslaughter trial.